Everybody, everybody can hear me okay? Everybody can see me okay, because I can't see you very clearly in these lights. So welcome to this afternoon's session. Do developing countries still have policy space to achieve their legitimate objectives under WTO rules? My name is Niall. I'm the moderator for this afternoon's session, which is put on by our organization, the Advisory Center on WTO Law. For those of you that aren't familiar with the ACWL, we're kind of a spin-off from the WTO that was set up in 2001 to provide legal aid, legal advice on WTO issues, including dispute settlement, to developing countries and to the least developed countries. We currently have a staff of 11 lawyers working full-time in Geneva on providing legal advice to developing and least developed countries. When we were initially set up, the expectation was to some extent that we would be largely involved in assisting those countries in WTO dispute settlement proceedings. In fact, a lot of our work is in providing day-to-day legal advice to developing countries. We provide almost 200 legal opinions per year. And a lot of those legal opinions are provided to developing countries on how they can implement their WTO obligations and whether their actions that they take are consistent with their WTO obligations. And this leads into today's topic, which is whether developing countries, and indeed others, have sufficient policy space under WTO law to achieve their legitimate domestic policy goals. And for this, we're delighted to have four excellent speakers with us. And I'm going to introduce them briefly before turning the floor over to the first of them. First will be on my left, Cherise Valles, who is Deputy Director of the ACWL and has been with the ACWL almost since the start. In her previous life, Cherise was a trade lawyer in the Canadian government for many years. We won't say how many, but then our second speaker on my right is Jaime Coghi, who Jaime has been also for a number of years the Deputy Permanent Representative of Costa Rica to the WTO and has extensive experience in all of these issues from the point of view of representing the Costa Rican government in the WTO. And he's been involved in all the negotiations over the past several years. And in addition has and I think is currently serving as a panelist in several WTO disputes. And so also brings to this the perspective not only of the developing country government official, but also of a WTO panelist charged with interpreting these obligations. Our third speaker is my other colleague, Alejandro Sanchez, who's counsel at the ACWL. He's been with the ACWL since 2010, and before that was a trade lawyer in the Mexican government and was involved in the early stages of Mexico's disputes on tuna and country of origin labeling, which are, of course, an important part of this discussion. And then finally, our last speaker on my very right is Gustavo Lunazzi, who's here representing the home team. Gustavo is, I first met Gustavo almost when I first moved to Geneva myself in 2004 when I moved into the same apartment building as Gustavo. And shortly after that, Gustavo left, or a couple of years after that, Gustavo left and came back to Buenos Aires and then spent 7 years in the embassy in Washington and now is in charge of WTO dispute settlement for the Argentinian government. And so also has a very good developing country perspective on these issues. We're going to start by having each of our speakers will have about 15 minutes, which I'll be strict but not very strict on. And then hopefully we'll have plenty of time for questions and answers and can have an interactive discussion of these issues. Cherise is going to start by reviewing the legal standard under Article 20 of the GATT, which is the basic legal provision protecting domestic policy space. and we'll talk about how that's being discussed in the jurisprudence. Jaime is then going to take the discussion from goods into services and talk about Article 14 of the GATS, which is the corresponding provision providing domestic policy space in trade and services. And we'll also discuss the ongoing negotiations and disciplines for domestic regulation. Alejandro will then talk about the policy space under other relevant WTO agreements, including the Tbt Agreement, TRIPS Agreement, and the Customs Valuation Agreement. And then finally, Gustavo is going to give a developing country perspective on how all this works in practice. What do all these rights and obligations mean in terms of what policy space is left to developing countries? So that's our program. Hopefully we will have an interesting discussion both from our four excellent speakers and also afterwards in an interactive discussion with you. So with that, I will hand it over to Cherise. Thank you.
Great. Thank you very much, Niall. Can everybody hear me? That's good. All right, good afternoon, everybody. It's a pleasure to be here. So as Niall said, I will start with the legal standard under Article 20, and this will be the agenda for my presentation. So we'll cover the function, the order of analysis, the various elements of the necessity test and the relating to test, and then move on to the chapeau of Article 20. Now, the basic function of Article 20 is to provide a bit of a safety valve for countries. So a country may adopt a measure that is inconsistent with its GATT obligations, provided it applies that measure in a manner that's consistent with the requirements under GATT Article 20. So you have a balancing act that is that takes place in GATT Article 20. So here is a schematic diagram of Article 20 with respect to the 10 subparagraphs that are in Article 20, divided into their general policy objectives, the product-specific policy objectives, and what is the legal test that you need to meet in order to show justification. Now, what's interesting is that even though there are 10 subparagraphs, only 5 of them have been interpreted by the appellate body, and those are the 5 that are in bold. So not all of the 10 subparagraphs have been interpreted. Now, there is an order of analysis that the appellate body has stated should be followed. So first, you must determine whether the measure is inconsistent with a provision of the GATT. And then if it is inconsistent, determine whether it falls under one of the subparagraphs. And if it does, then whether it meets the requirements of the chapeau. Now, interestingly, this order of analysis has been followed by practically every panel and the appellate body since U.S. gasoline. But there was a recent case in Indonesia import licensing requirements where the appellate body said it's not necessary 100% to follow this order of analysis as long as you address all of the elements that are captured in both levels of the analysis. So this is what we have in the necessity test. There's basically a 4-part necessity test. One, you have to determine what is the value of the interest that you're trying to protect. Second, what is the extent that that measure contributes to achieving that objective? Is it a material contribution or is it merely apt to contribute? Third, what is the extent to which the measure has a restrictive impact on international trade? And fourth, are there reasonably available alternatives that could make the same contribution that the original measure made, but in a less trade restrictive manner? So first, how important is the value? Well, in EC Asbestos, the appellate body said, you know, something like the protection of human health is the most vital and important value. In Canada Wheat Board, the fact that the measure was just with respect to ensuring the quality of grain and protecting consumers was important, but not as important as protecting health. And in Dominican Republic cigarettes, you know, the fact that a developing country wanted to protect against smuggling, etc., was an important value. Quite frankly, almost every value is an important value. It's very hard to say that a value that a country is trying to protect is not important. So this is a very straightforward part of the test. The second aspect is to what extent does the measure actually contribute to the policy objective? And this is the more difficult part of the analysis. It's not necessary for a panel to make a quantitative assessment of contribution. So in EC seals, the panel basically said it contributes to a certain extent, and this was determined to be sufficient. In terms of the degree of contribution. Third, to what extent does the measure have a restrictive impact on international commerce? So if the measure has a very restrictive impact, then it will be more difficult to consider it to be necessary. If it has a light impact, then it'll be easier to consider it necessary. So it's a bit of a sliding scale with respect to this component. And then fourth, are there less trade restrictive measures that are out there? And it's important that these alternative measures are not just theoretical. They have to be actually reasonably available to the member concerned. And that alternative measure must actually contribute to the objective that is being pursued. So all of these elements together, you know, must be weighed and balanced in a holistic manner to determine whether the measure is necessary. So with respect to public morals, what is important is that members can set different levels of protection. You have to determine whether the measure is designed to protect public morals, and then whether the measure is necessary to protect public morals. So similarly, with respect to Article 20B on public health, you need to determine what is the policy objective, and then look at whether the measure is apt to produce a material contribution. Can you determine this through qualitative projections or qualitative reasoning, etc., if you don't have evidence of the material contribution already? With respect to 20D, you can take measures that are necessary to secure compliance with your laws and regulations, provided certain conditions are met. So the first condition is that the measure must be designed to secure compliance with your laws and regulations. Those laws and regulations must not be inconsistent with the provisions of the GATT. And once again, the measure must be necessary to secure compliance with those laws or regulations. So there must be an enforcement mechanism. Importantly, the respondent must identify the laws and regulations that the challenged measure seeks to secure compliance with. And you would think that this would be a fairly straightforward requirement, but in fact, there have been a few cases in which the identification of the laws and regulations has not properly taken place. And the laws and regulations must be distinguished from trying to achieve the general objectives of those laws. So you must actually achieve compliance with the laws and not achieve compliance with furthering the objectives of those laws. Now, can a member invoke Article 20D to induce another member's compliance with international obligations? And this came up in Mexico soft drinks, where Mexico invoked 20D to defend its measures in order to get the United States to comply with its obligations. And both the panel and the appellate body rejected this and said that the laws and regulations are domestic laws and regulations. And then we have 20G, which allows members to adopt measures relating to the conservation of exhaustible natural resources, provided those measures are made effective in conjunction with domestic restrictions. So this is the three-part test under subparagraph G. So each of these elements must be made out before you can have your defense under the subparagraph. And then we come to the chapeau, and it has been made clear by the appellate body that the chapeau does not address so much the content of the measure, but the manner in which it is applied. So to meet the requirements, the measure cannot arbitrarily or unjustifiably discriminate between countries with the same conditions, or be a disguised restriction on international trade. So that's sort of the standard that is applied in order to see whether you can make out a defense under Article 20. The appellate body has said that in determining whether it meets the test under the chapeau, it should focus on the cause of the discrimination or the rationale, and whether the conditions prevailing in the different countries are, basically the same. So this is, in essence, what one has to do. You have to justify your measure under the relevant subparagraph. The burden would then shift to question the value of the importance of the interest, the value of the contribution, whether it has a restrictive impact, identify the LRAs. The burden would then shift back to say that the LRAs are not reasonably available or do not achieve the same contribution. Then you would have this holistic weighing and balancing, then to determine whether it's provisionally justified before you get to the chapeau. So it's a fairly detailed and exacting legal standard that has to be met in order to make out your case under Article 20. And I'll stop there. Thank you.
Okay, thank you, Cherise. And as I mentioned at the start, I think we'll go through all the presentations and take questions at the end for each of the individual speakers. So if you have any questions based on what Cherise just said, we'll come back to them after the four speakers have spoken. So with that, I'll turn over to Jaime Coghi.
Can I have the... Thank you. Good afternoon to everybody. I would like to start my presentation thanking the ACWL for inviting me to share with you the perspective of a services negotiator of Costa Rica. And the perspective, I will try to speak about the legal analysis of these articles, Article 14 and Article 6 of the GATS, but I cannot avoid to bring with me as well the political and the perspective of a developing country. And I would like to start talking about the relation with policy space, which is one of the issues that we are talking about here. How does it work?
Right click. Oops. Okay,
I'm going back to your presentation.
How do we find the next one?
Forward. No, you're going backwards.
Okay, so next one.
You have to go the one on the right.
Very good. Keep going.
Keep going.
Uh-huh. No.
No.
You have to go back where you find your name. I think you pick your name.
Ah, okay. That's the. Yeah. You.
Okay.
No.
No.
Because maybe you were before. Yeah. Before, yeah, because it wasn't in order.
Back. There we go.
Okay.
Here we go. And then.
Okay.
Oh, help me, please.
No. And now, okay. No?
Okay, no. Well, I'll start on my presentation. I would like to bring here the perspective of the GATS, because the GATS is in itself allows for a policy space in many of its articles. And we're talking about these articles. I would like to start from this discussion on the perspective of what's the meaning of GATS. Because his characteristic, one of the characteristics of this agreement is an shift agreement. It's still under negotiation in many parts. And after all, it's a very first attempt to discipline services in a multilateral forum. For its very nature, the GATS follows a very flexible approach, as you know, and allows countries to define themselves the policy goals they want to pursue and take them into account in the specific commitments. So we have in the GATS a positive list approach to undertake commitments under Articles 16 and Article 17 related to specific commitments and national treatment or market access. And this is, for us, the most significant expression of the will to allow each WTO member to decide which sectors commit and the depth of these commitments. So the structure of the GATS is in itself an attempt to balance, from one side, the objective of progressive trade liberalization and predictability of the commitments undertaken, and policy space in the other side. This is reflected in many articles of the GATS. It's not only Article 14 and Article, and I will talk also about Article 6 of the GATS, but you can see that in the preamble of the agreement that recognizes the right to regulate, the Article 19 on negotiation of specific commitments that recognizes the respect for national policy objectives and the level of development of individual members. We have also Annex 2 that allows, Annex on Article 2 exemptions that allows members also to provide a different treatment to other countries, provided that this treatment is, this preferential treatment is included in each national list. And finally, the prudential measure, the principle contained in paragraph 2 of the Annex on financial services. Given that introduction, so I wanted to now to move to Article 14. If we have the presentation, maybe.
We're getting there, but not quite there.
Okay. Well, Article 14 of the GATS it follows the same structure and is very similar to Article 20 of the GATT. If you take the chapeau of both articles are almost a copy. Article 14 is almost a copy of Article 20. The chapeau of Article 14 is almost a copy of Article 20. And the list of exceptions are pretty similar to those of Article 20 of the GATT. So taking that into account, WTO adjudicatory bodies have followed an identical legal standard of review. And in particular, in the case US gambling, the appellate body stated that first, it should be determined whether the improved measures falls, as explained by Cherise, falls under one of the Article 14 justifications, one of the justifications, and then if it follows, is potentially justified, establishing a sufficient nexus of degree of connection between the measure and the interest to be protected. And second, whether the measure is compatible with the conditions of the chapeau. So if we go to the exceptions provided by Article 14, they are, well, similar to those of Article 20, but are not the same. And if Article 20 has 10 exemptions, in the case of Article 14 has only 5. Okay, here we are.
There you go.
I'm safe now. So, well, I wanted to stress that I'm going to talk about Article 14 and Article 6. and Article 14, according to the WTO adjudicatory bodies, both the panels and the appellate body, in particular U.S. gambling, considered that it has to follow almost the same kind of analysis that Article 20 of the GATT.
We should have done that from the very beginning.
Okay, let's go to the specificities of the Article 14. The first, as I told you, Article 14 has 5 rules, according to which a member can deviate from the GATT and the commitments it has undertaken, compared with only with 10 exceptions contained in Article 20. So the list of GATT is shorter. It could be related to the fact that the different nature of the services compared with goods that do not justify all the situations. This can also be attributed to the fact that the descriptions of the exceptions are in some cases broader and can be reasonably argued that they may include some of the absent situations from Article 20. So the first one is necessary to protect public morals or to maintain public order. I wanted to, well, you can see it's in red, or to maintain public order is an addition of GATT's drafter to the situation on Article 20 of the GATT, because Article 20 of the GATT only relates to protect public morals, but it does include the maintain public order, which is a new situation. GATT therefore goes beyond the exception of Article 20, and in the case of U.S. gambling panel, there was this discussion about the meaning of public morals and public order, the interpretation of both. And interesting, the U.S. gambling panel, in some of their reasoning that were not appealed, considered that public morals, the situation of public morals and public order, and said that two concepts can vary in time and space. Public morals refers to standards of right and wrong conduct, and for me as a representative of a country is that each member is free to determine its own appropriate level of protection or enforcement of WTO consistent laws. For me, is the most interesting part. Saying that the new addition of public order is not as broader as you may think, in the sense that there is a footnote that frame how to interpret this situation. So this public order exception may be invoked only where a genuine and sufficiently serious threat is posed to one of the fundamental interests of society. So public order seems to refer, even if public order seems to refer to a broader concept, given footnote 5, GATT's drafter wanted to limit the scope of this public order exception situation to the seriousness of the threat and the importance of the society at stake. The standard required by this footnote 5 reflect the will of members to avoid minor deviations from the substantive GATT's obligations and allow them under serious circumstances. The other situation is the necessary to protect human, animal, or plant life or health. This is identical to the exemption of GATT. Here, I would like to stress that since GATT's Article 14 does not contain an exemption on the conservation of natural resources, this exemption should be expanded to the protection of living resources. And in fact, the Committee of Trade and Environment concluded that this should be interpreted widely and include measures to protect the environment in the sense of living resources. Next situation is the one to necessary to secure compliance with laws or regulations which are not inconsistent with the provision of this agreement, which is pretty similar to the one of the GATT, containing in Article 20 of GATT. Interesting point is this is not this is an illustrative list of interests. It's not a numerous clauses list. It says including two. One example could be the enforcement of regulation that require treating foreign services or foreign services providers differently from domestically established providers in terms of procedures and administrative controls. And finally, the last two exemptions regards to both of them to taxes, taxation. One is regarding paragraph D, relates to a difference in treatment to foreign services or foreign service suppliers for imposition or collection of direct taxes, and therefore a deviation from the national treatment commitments. And paragraph E relates to a difference in treatment as a consequence of a double taxation agreement, and therefore a deviation from most favored national treatment. Let's go now to the necessity test that Cherise has already explained in depth. According to the WTO case, both Article 20 of the GATT and Article 14 of GATT, the necessity of the measure is a key requirement, and both entail a necessity test. In the case of Article 14, contrary to what happened to Article 20, we have the first three situations are linked to the necessity test. The other two could be interpreted that they may have a different standard in the sense that the measures are aimed to ensuring the equitable of effective imposition or collection of direct taxes, and the other is the result of an agreement. But in any case, there should be this connection between the measure and the necessity of the measure. In Article 14, Article 14 of the GATT does not distinguish between measures necessary for and those merely relating to. I just want to move quicker because we go now to the chapeau, which is also a condition for the standard of review. And here in extensive GATT Article 20 case law can be applied mutatis mutandis for the interpretation of the chapeau of Article 14 of GATT. The chapeau has been interpreted by the appellate body as containing three accumulative standards: the arbitrary discrimination between countries where like conditions prevail, unjustifiable discrimination between countries, and disguised restrictions on trade in services. Finally, the other aspect of my presentation is about domestic regulation. This issue has been already discussed in another panel today, and my intention is not to cover in depth all the different aspects, but to provide a general perspective of this issue in the context of the discussion of policy space and the current situation of MC11, because this issue is being discussed right now in the negotiations. I would like to start saying that regulation of services is primarily a matter of domestic law. GATT's preamble recognizes the right of members to regulate and introduce new regulations in order to meet national policy objectives, and recognizes in particular the right of developing countries to exercise this right. But many domestic regulation barriers are often less visible than entry restrictions like equity caps or joint venture requirements or restrictions on cross-border delivery, which often have a more transparent legislative basis and which can be scheduled under Article 16 of GATT. So these types of administrative barriers can be unsurmountable unsurmountable for micro, small, and medium enterprises and can be the difference between entering a market or not. So we are not talking here about measures that can be scheduled under Article 16 related to specific commitments on market access, or Article 17 of GATS relating to national treatment commitments. Those articles are all about all the political space a member wants to reserve to its own. And if it wants unlimited political space in a specific sector, sufficient not to take commitments under those articles. Do not take commitments as part of their list of commitments. What we are talking here about is about regulations that can affect actually the fulfillment of the commitments undertaken by a given member. So they are, in principle, neutral regarding Article 16 or 17 of the GATS, but can affect their operation. The disciplines in this area are intended to facilitate trading services and are not for market access commitments. This is actually why we are dealing with negotiations on domestic regulation now. But this is a mandate that comes from the Uruguay round and is part of the GATS itself. Contrary to other issues of negotiations, this one was agreed and is part of the legal commitments of WTO members, and is a commitment that we haven't fulfilled yet. With these introductory remarks, I would just like to call now your attention on the elements of paragraph 6 of the GATS. There are already some obligations in Article 6 that members have to comply with, like ensure that all measures of general application affecting trading services are administered in a reasonable, objective, and impartial manner, maintain or institute judicial, arbitral, or administrative tribunals or procedures, etc. But negotiations are under Article 4 under Paragraph 4 of Article 6. And Paragraph 4 mandates for specific negotiations relating to three aspects: qualification requirements and procedures, technical standards, and licensing requirements. The objective of these negotiations is that these kind of barriers do not constitute, this kind of regulations do not constitute unnecessary barriers to trading services. And the conditions are that they are based on objective and transparent criteria, not more burdensome than necessary to ensure the quality of the service, and the licensing procedures not in themselves are a restrictions or could be a restriction on the supply of a service. We have been working this for a long time. In 2009 and 2011, we were very close to reach an agreement, but failed. The chair's text did not achieve sufficient convergence. Now we have a text of a group of delegations. Costa Rica is part of this initiative, and with limited scope with some disciplines that we wanted to continue or to be agreed here in Buenos Aires as our first option, but if not, that at least to continue discussing on them in the future. And these disciplines have a very limited scope that would apply only to measures relating to licensing and qualification requirements and procedures and technical standards, only apply to sectors where commitments are scheduled and subject to any limitations. The disciplines recognize the right of members to regulate, are aimed to facilitate trading service, and cover administration of measures, transparency, technical standards, development of measures, etc. And we have some rules for that includes flexibility for developing country members. I think that's what I can say regarding Article 14 and Article 6 and the current negotiations on domestic regulations.
Thank you very much, Jaime. And now we'll turn it over to Alejandro Sanchez.
Thank you. Hello? Does it work? Yes? Okay, I'll make sure that my presentation is on so to avoid further technical problems. He's finding it. Anyway, I'll give you a brief...
maybe if I point it?
No, he's opening it there directly. Hope so.
Okay.
Yeah, there it is. So I'm going to talk about policy space, the same subject that you've been hearing for the past minutes, but the way in which it is applied in other WTO agreements. You heard from Cherise and from Jaime the legal standard for GATT Article 20 and GATT's Article 14. Now, there is an obvious limitation on the scope of Article 20 and Article 14, and that is that it only allows developing countries to depart from obligations that are contained in these agreements. I mean, let's just take a look at the text of Article 20. It's very clear. It says, subject to the requirements, et cetera, nothing in this agreement shall be construed to prevent. This agreement means the GATT. This is what Cherise explained. What Jaime explained was the GATTs. The GATTs has a very similar formulation. So everything that you heard from Cherise and from Jaime are the rules for a country to deviate or depart from WTO rules when it wants to pursue policy objectives. But what about the policy space to pursue objectives in fields that are not the GATT or the GATTs? As you know, WTO law covers other agreements, the technical barriers to trade agreements, sanitary measures, intellectual property. Where is the policy space in those agreements? Does it mean that because those other disciplines are not contained in the GATT or GATTs, there is no policy space? Well, sorry now. it's fine.
Am I reading the right way?
The short answer to the question is yes, there is policy space, and I will explain why there is policy space. It's a bit tricky, because in these other agreements, there is no nice textual hook as Article 20 of the GATT or Article 14 of the GATTs. Let's start with the Tbt Agreement. This is the agreement on technical barriers to trade. Technical regulations are covered in this agreement, also commonly known as standards. You know, we're talking about laws on packaging, on labeling, etc. Now, there's one of the main obligations of the Tbt Agreement. It's Article 2.1, which contains the national treatment obligation. I think we're all familiar with that. You cannot discriminate in favor of your own domestic products. It also has an MFN obligation. You cannot discriminate among third parties. So that's fine. That's similar to Article 3 of the GATT and Article 1 of the GATT. Where's the policy space here? Apparently, there isn't any policy space. But adjudicators know that policy space, that is the right to pursue other goals that are not trade-related, is indispensable. So a few years ago, in this dispute, U.S. clove cigarettes, the appellate body was faced with this issue. And what it did, the appellate body said, well, you know, maybe there is no pretty Article 20 provision here, but there is nonetheless the possibility to depart from the general obligation of Article 2.1 of the Tbt Agreement. And the language that it provided is that if a measure stems exclusively from a legitimate regulatory distinction, it will not be a violation of the national treatment obligation or the MFN obligation in Article 2.1. There is, as I indicated, no Article 20 text, but the appellate body found support for this conclusion in the preamble of the Tbt Agreement. It was debated because they said, well, can you really extract a carve-out as big as this one from the preamble? But these are the realities. The realities is our policy space is very important. So the appellate body decided to do it, and it said that that was a fair way of doing it, and I think people agree with that. Now, let me just give you some brief background on this U.S. clove cigarettes. This was a dispute brought by Indonesia against the United States a few years ago. The United States banned all flavored cigarettes, flavor, cigarettes that have some flavor. But actually, the prohibition only applied to a segment of those flavored cigarettes, which is cigarettes that have clove flavor. This very nice species. And well, the appellate body said, you know, there's a discrimination here, and there is no rationale. There is no policy rationale why the U.S. applies only this prohibition against clove cigarettes, but coincidentally allows domestic cigarettes with menthol flavor, which also falls under the category of flavored cigarettes, to not be subject to the prohibition. And well, you know how we are, all lawyers. We like to litigate and reinterpret the words. So this legal standard of stems from a legitimate regulatory distinction has been interpreted again and again. And one of the further elaborations of that is that if the measure that has been found to, in principle, be a discrimination, if this measure is not even-handed, it will not pass the test of falling within the policy space of Article 2.1. And that is one of the findings of this other dispute, U.S. School. It's supposed to be a dispute brought by Canada and Mexico against the United States on country of origin labeling. Now it's your turn, Cherise. Here's the type of label usually. Oh, you cannot see it, but it says product of the U.S., product of Mexico. And what... Thanks, Cherise. Okay. No, what the violation there was another discrimination violation. The appellate body said that the fact that you need to have this label, that involved a lot of segregation in the upstream of cattle and hogs, and that was a violation of Article 2.1. And the second step of the analysis came in, well, was this adopted to pursue some policy space? And the finding was that no, it is not even-handed, so it didn't pass the test. So this is the Tbt Agreement, Article 2.1. If you want to know more about the Tbt Agreement, there's Article 2.2, another important and very loaded obligation. This is not about discrimination, but this is about the obligation to make sure that your technical regulations are not more trade restrictive than what they absolutely have to be. So no more trade restrictive than necessary. Now, this word, than necessary, this is the necessity test that Cherise and Jaime described. So again, although it is not spelled out in detail, this necessity test was interpreted in the case law to provide for policy space for the country that is adopting a technical regulation and that is being accused of being too stringent with respect to the requirements. So the appellate body said, you have the word necessary, that means necessity test. And it involves all these things, which I think is better not to repeat because it was already explained. You have to first do a relational analysis. How restrictive is your measure, let's say your technical regulation on helmets, on the material for helmets? Is it that restrictive? Are you demanding that all helmets be made of the most expensive material of titanium because that's the only thing that will ensure the protection of the head? That may be a violation of 2.2 because it's more restrictive than necessary. But you still have to go through all these steps. What is the contribution? Are you alleging that this is to protect, probably if it's helmets, to protect public health? Well, that's to really achieve that. I'm going to skip to this last one. But is there an alternative way that you could have achieved that same objective without being as restrictive? Did you really have to require that this very expensive titanium material be applied? Couldn't you have gone just for a simple plastic that is hard enough? So this is also part of the policy space because it allows countries to have restrictive measures, but if it's demonstrated that this pursues a policy objective, if it has a sufficient degree of contribution, and there was no other way of doing it, then it's going to pass the test of this legal provision. And by the way, it's interesting because to date, there have been many claims of violation of 2.2, but all of them have failed. So that means that the WTO adjudicators have recognized that the country adopting the measure was within its right to pursue a legitimate objective. Now let's go to the SPS agreement. This is the agreement on sanitary and phytosanitary measures. Here we have a different twist. Well, sorry, just a brief recollection. Some of the main obligations are that the measures may not be more restrictive than necessary, and that they have to be based on scientific evidence. We have here a text from Article 2.4 of the SPS agreement that is particular, because it makes a specific link to Article 20b of the GATT, which is what Cherise explained. It said SPS measures that conform to the provisions of this agreement will also conform to the provisions of the GATT. So here you have a demonstration of coherence between the original GATT obligation that stems from 1947 and the quote-unquote new agreements from 1995. So you can say that the SPS agreement is already the elaboration of policy space for countries that want to adopt measures that have some type of pest or plague, and that normally this would be a restrictive measure. But if you satisfy these requirements, you are within your right to pursue this type of measure to protect health. Now the TRIPS. This is the agreement on intellectual property. Is there policy space here? This is where it starts to get a bit tricky. The answer is yes. The TRIPS is a particular agreement because it has its own set of obligations, but it also incorporates many provisions from older intellectual property treaties like the Berne Convention. So yes, there's policy space embedded throughout the TRIPS agreement. For example, we have this article from the Paris Convention that allows WTO members to deny trademark registration if these trademarks are contrary to morality or public order. So there is already some space, not by means of an exception, but by means of what a country is allowed to deny at the very beginning. This is in the field of trademarks, logos, etc. We have also in the field of trademarks, there's Article 20 of the TRIPS agreement that allows countries to encumber. To encumber means to complicate, to make life a little bit more difficult, to encumber the use of a trademark with special requirements. So if the country thinks that your logo and your word need an extra word to clarify something about the product or to clarify what this is the type of product, this is a special derogation from those general trademark rights. So the countries have the right to modify your trademark a little bit if they think it's necessary. And finally, I think something that we're all familiar with, the issue of compulsory licensing. The TRIPS agreement allows countries to grant a compulsory patent license in the event of a public health contingency. You can produce medicines without the consent of the pharmaceutical company. So this is the TRIPS. Now, going back to the GATT, Article 20 of the GATT, can you still use the GATT to invoke it as a justification for other non-GATT obligations? Here we're getting into a terrain of debate. Now, what about invoking Article 20 of the GATT to justify a violation of the customs valuation agreement? This agreement, the customs valuation, gives you rules on how you determine the amount that is going to be dutiable, that is going to be the basis to levy your customs duties or your taxes like the VAT. Here, the interesting thing is that this agreement has a specific title, which is Agreement on the Implementation of Article 7 of the GATT. So it has a link to the GATT. So an argument could be made that if Article 20 applies to violations of the GATT, and if the Agreement on Customs Valuation, as its title indicates, it's an elaboration of Article 7 of the GATT, then Article 20 should be allowed to justify violations of this other agreement. This is still something that has not been resolved in the case law. We have this other dispute, the U.S. Customs Bond, where the issue arose of whether Article 20, again, could be used to justify violations of the anti-dumping agreement, something that is completely different from usual GATT rules. And the appellate body did what it always does, which is I don't need to get into that debate. Okay, I'm going to resolve the issue by dealing with all these things, and we make no finding as to whether or not GATT Article 20 could apply. It said it may or it may not, but the door was not entirely closed. And finally, this is also the object of debate. As you know, countries that accede to the WTO have to have a protocol, and they usually undertake additional obligations that are not applicable to the original WTO signatories. These are the WTO plus obligations. China has, in its disputes, said, well, you are claiming a violation of one of my WTO plus obligations, but I can always invoke Article 20 of the GATT. And the answer there is, in principle, no. Because GATT, Article 20 only applies to GATT obligations, and these WTO plus are in addition to the GATT. So China, if you would have wanted Article 20 of the GATT to be applicable in the event you have a public policy justification, you should have included that in your protocol, and you didn't. So the answer thus far has been a no. And China still believes that it should have, it still continues to say that it should have had the right to justify its mention in Article 20 in respect to the protocol. So this is, in a nutshell, the places where we can find policy space in other parts which are a bit harder to find that are not the GATT or the GATTs. And now we're going to pass the floor to our colleague Gustavo Lunazzi, who's going to address the hardest part of this session. How does this apply to developing countries? They're going to use the USB, yeah.
Gustavo, he's a...
okay.
There we go.
So, good afternoon, everyone. And at the outset, I would like to express my appreciation to ICTSD, the ACWL, and Niall also for inviting me to join this distinguished panel. I'd like to address two statements that are usually heard when referring to the interpretation of the general exceptions under Articles 20 of the GATT and 14 of the GATT. First is that the measures covered by the general exceptions are very hard to be upheld in the WTO dispute settlement system. When you see the number of cases in which general exceptions were invoked, you could see that you can see that just in only 2 cases where general exceptions were invoked out of 35, general exceptions were upheld. In one of these 2 cases, it's under appeal right now, even. So, secondly, the second statement is that the interpretation made by the WTO jurisprudence does not leave enough policy space for developing countries. However, in my opinion, this statement needs to be put in the proper context. Among other aspects to be considered, I would like to stress that avoiding the use of general exceptions is also is at least as important for developing countries as preserving policy space. On the first statement, it's commonly suggested that general exceptions are very hard to apply and do not leave enough policy space for members. I mentioned these 2 cases out of 35. However, I think merely quantitative analysis might lead to error, at least for 3 reasons. First, these quantitative analysis do not take into account the fact that many measures that might be justified under general exception might never be brought to the WTO. perhaps it's safe to assume that when a member brings a measure purportedly justified under a general exception to the WTO dispute settlement system, there is a certain suspicion on whether this measure is indeed justified or not. Second, one should also bear in mind that there are 7 very important cases, 5 under Article 220 and 2 under Article 14 of GATT, where the challenge measure is not justified under a general exception, but just because it cannot satisfy the test of the chapeau. That is, the measure satisfies the conditions of the specific subparagraph invoked, but is considered discriminatory in its application or a disguised restriction on international trade. However, the jurisprudence established in these cases should not be minimized. I think it's very important. As a matter of fact, the failure to comply with the conditions of the chapeau cannot be seen as a total failure from the point of view of the member that was trying to justify the measure. In first, because sometimes the discrimination of the chapeau is easy to fix. Second, because these cases evidence that members were indeed allowed to preserve their public policies, provided that they apply those policies without discrimination. A third element is that invoking a general exception is often a subsidiary defense in the context of a member's legal strategy. In 7 out of 33 disputes where Article 20 was invoked, the appellate body or the panel exercised judicial economy and did not even consider the general exception. So numbers might portray a misleading picture sometimes. So all things considered, despite these quantitative assessments, when you go into the details, the overall picture is not as bleak as it appears at first glance. The second statement I wanted to address is that statement that says that the interpretation made by the WTO jurisprudence did not leave enough policy space for developing countries. I think personally that the jurisprudence of the WTO has struck a very careful balance between policy space on one hand and the need to preserve the multilateral disciplines. And this balance is extremely important for developing countries. In fact, general exceptions have been invoked 70% of the time by developed countries, not by developing. In 23 out of 33 times the Article 20 of GATT was invoked, it was done by developed countries. Half of those times against developing. This highlights that the balance established by the jurisprudence is something very important because the general exceptions many times are used against developing countries. So there is the balance between regulatory autonomy and respect for the multilateral disciplines is of crucial importance. For example, for my country, an agricultural exporter, a developing country, avoiding the abuse of Article 20b is very important. Many times Argentina has been frequently the subject of measures that were allegedly adopted to protect human, animal, or plant life or health, but which were not adequately justified from a scientific point of view. at least. I would like to turn now to a number of findings on sorry. I'm sorry, I touched it. I would like to turn to a number of findings about general exceptions that can be considered important for developing countries, either because they preserve flexibility in their application of public policies or because they avoid potential abuses in these exceptions. Concerning Articles 20A and, of GATT and 14A of the GATT's measures designed to protect public morals or maintain public order, as measures, as mentioned by Jaime, U.S. gambling is a very important case, and also EU seals. I find a very important case where a very important development by jurisprudence. These two cases upheld the measures as necessary to protect public morals or maintain public order. In U.S. gambling, the panel defined public morals in broad terms, establishing that those were concepts that could vary in time and space depending on a range of factors, including prevailing social, cultural, ethical, and religious values, and acknowledged that WTO members should be given some scope to define and apply for themselves those concepts. In the same vein, in EU seals, the appellate body provided even more flexibility regarding subparagraph A, clarifying that members have the right to determine the level of protections that they consider appropriate and may set different levels of protection even when responding to similar interests of moral concern. Regarding very quickly Article 20B, measures necessary to protect human, animal, or private life or health, the jurisprudence developed in the dispute Brazil retreated tires is significant for developing countries too. Although the Brazilian import ban on retreated tires was ultimately found to be discriminatory in its application, the principles set out by the appellate body in this decision grant considerable flexibility to WTO members when they take trade restrictive measures to protect lives or health. The appellate body affirmed that any consideration of alternative measures, for example, must take into account the capacity of a country to implement such measures. This means, for example, that what may be considered as a viable alternative measure for a developed country may not always be regarded as appropriate for a developing country or a least developed country. This is a clear finding granting flexibility for developing countries in this sense. Indeed, this case was important for Argentina because Argentina had at that time a similar measure that was not brought to the WTO, but it was brought to the Mercosur tribunals. And even after the issuance of the appellate body report. This was, and Argentina invoked, the issue was, this was an import ban also designed to prevent environmental liability produced by the accumulation of retreated tires. And Argentina invoked Article 50 of the Treaty of Montevideo, which applies to Mercosur, and it's very similar provision to Article 20V of the WTO. Different from the WTO decision, the Mercosur permanent review tribunal was much harder, but much harsher than the WTO appellate body, and did not contemplate any did not give any deference to policy space or did not give any deference to the departed from the factual findings of the WTO panel, and including found that the environmental liability alleged invoked by Argentina was neither serious nor irreversible, and did not justify under Article 50 this measure. It was a decision which was much harsher than the WTO appellate body, only took into account trade considerations. And I think it's a paradox that a regional tribunal from a customs union exclusively formed by developing countries interpreted a similar exception in a much more strict way than the WTO. So WTO tribunals were not as harsh after all. Third, regarding measures necessary to secure compliance with laws and regulations, this exception contemplated in Article 14C of GATS, but that could be applied also to Article 20D of GATT. I think the findings in Argentina financial services have an important value of precedence too. Argentina successfully defended 8 challenge measures that were designed to protect Argentina's tax base by preventing tax evasion, tax avoidance, and fraud. Argentina's law distinguishes between countries cooperating for tax transparency purposes and countries not cooperating for such purposes. Indeed, the measure discriminates but serves to prevent concealment and laundering of money of criminal origin, and were meant to protect investors and the soundness of the financial system. The appellate body confirmed that all those measures, those 8 measures maintained by Argentina, which largely abided by OECD recommendations, were deemed necessary to secure compliance with the Argentine income tax law under Article 14C of the GATS. This is an important finding in terms of granting flexibility for public policies. In this case, finally, the issue of the general exception became moot because in the end, the appellate body did not find Argentina was in breach of any substantive rule in the first place. However, the importance of these precedents remains. Lastly, I was just a word on something which was touched by Alejandro, the importance of the precedent established in China raw materials as regards the scope of application of Article 20. this report appears to decide a protracted controversial issue over which panels and the appellate body for some time had avoided deciding. That's whether the general exceptions contained in Article 20 can justify measures in breach of WTO agreements different from the GATT. In this case, the appellate body seems to confirm the existence of a rebuttable presumption, that is that Article 20 can only be invoked outside the scope of the GATT 1994 when the breach provision includes a hook, a direct reference to Article 20. This decision is important in as much as it preserves the balance, I think, between regulatory autonomy and multilateral disciplines. Article 20 clearly cannot be established as a meta defense. In concluding, I would say even if a mere quantitative analysis might suggest that the interpretation of the general exceptions under WTO law is very restrictive, I think, in fact, the jurisprudence has struck a careful balance between the regulatory autonomy of the members and the compliance with multilateral disciplines. This is particularly important for developing countries, which many times were on the receiving end of an general exception. I think I have consumed my time, so I thank you all for your kind attention.
Thank you, Gustavo, and thank you to all of our speakers. We're running a little short of time, but since we got started a little bit late, perhaps we can have the organizers' indulgence to have a few questions. So, well, and here we have a question right in the front row. So, and perhaps for there are no strangers here, but there are some friends I don't recognize. So perhaps when you ask your question, you could identify yourself for the audience.
Do I need to use the microphone?
I think we have a microphone here.
Thank you very much to all of the panelists. It was very, eye-opening. I'm Pınar Ertren with Istanbul Big University, and I'm the WTO chairholder as well. I guess I have one question at least per speaker. Let me start with you, Gustavo. You said some, statistics about, developing countries using less Article 20 or developed countries using more Article 20 against developing countries. Do you have any statistics to how much developing country uses Article 20 against another developing country? That would be my question too. Can I just perhaps finish,
sure.
Then I give you the chance to. And if I come back to Cherise, when you are making the test under Article 20, we always, perhaps forget about where the same conditions prevail, which is written in the chapeau. What is the value you attribute to the where the same conditions prevail, and how do we apply that test to Article 20? Moreover, I would like to perhaps, to both of you, the comparison between Article 24 and Article 20, because both of these provisions says nothing in this agreement. So if I can, make the argument that nothing in this agreement also includes covered agreements, since it's part and parcel under public international law, can I perhaps say that the anti-dumping agreement, because the name is the implementation of Article 6 of the GATT, Article 20 would bring a justification to anti-dumping measures which are applied if you make that comparison in relation to the customs valuation agreement. So I was wondering what would be your approach to those issues. Thank you.
Maybe before we answer, we'll take one more question, and then I'll ask all of our panelists to have 30 seconds to respond. Please.
Yeah, thank you very much. My name is Christine Wieck. I'm an agricultural economist, and I'm with German Development Corporation. Thank you very much to make all these legal texts also accessible for an outsider like me. So I have a question, or is your interpretation of the legal text that there is sufficient policy space, or that there's enough policy space? And then my question is, if we talk about, or if developing countries, and here I'm talking about least developed countries, low-income countries, in particular in Africa, if they want to develop their rural sector, their rural economy, then what's needed is economic development in the rural sector, and what they produce are agricultural commodities, and these are often in competition with imported commodities that are much cheaper, have a better quality, and are sought after in urban communities, mostly at the coastal line. So what can they do to develop the rural sector from a legal perspective? Thank you.
Okay, thank you. So one last lady with the glasses there, and then we'll have a very quick response, but we can continue the discussion in a less formal setting once we break up.
Okay.
Please.
Thank you. I'm Denise Rodriguez, University lecturer from Bolivia. My question is related to the GATS agreement. I think the tricky part to GATS measured is that services and the services suppliers and mode of supplies can be considered as different matters. They are completely different, and it's also problematic to draw a line between goods and services. So my question is: a measure against the freedom of transit of goods should fall within the scope of GATS or GATT, and if it's services, or it is services or a good, and it is services, what about the services supplier?
Okay, thank you. And I'm going to give each of the panelists 30 seconds to respond, and hopefully we'll cover all those. And so I'll start with Alejandro, and we'll work across maybe you could start with the last one.
I think I'll focus on the first one because it was addressed directly. You asked whether someone can invoke Article 20 to justify a violation of the anti-dumping agreement. Well, that is the big question mark. Well, first of all, it will be hard to think of a situation where a country would have to depart from the anti-dumping rules because of a public policy objective, because of a health issue or environmental issue. So the factual issue is complicated to imagine. Now, the legal aspect, that is a big question mark. That's exactly what we're raising. It hasn't really been tested in dispute settlement, but an argument could be made based on exactly the title of the agreement, which, as you indicate, seeks to elaborate something that already exists in the GATS. We don't know. We don't know, and we will have to see. And I think it also depends on the specific facts.
Cherise?
Okay, well, I'll take Pinar's question first. I mean, I think the issue of discrimination between countries where the same conditions prevailed just adds another dimension to the arbitrariness of the discrimination. So the discrimination has to be related to the fact that if the same conditions prevail and you treat one country differently from another, then that is the basis for the finding that there's arbitrary or unjustifiable discrimination. I think that's perhaps the only way that one can address that. With respect to the question on transit, Article 5 of the GATT specifically deals with the transit issues. So it regards transit of goods as falling under the goods agreement, basically. Yeah.
Thank you. Jaime, your turn.
Depends on what your depends on what your commitments are for, let's say, maritime transport or land transport, etc. Yeah.
Jaime, your 30 seconds.
Thank you. Thank you. I just want to finish to wrap up with a reflection from the balance between policy space and the predictability. So policy space is up to some degree necessary to each member, and it's important to each member to adapt to new circumstances and challenges that can arrive as a consequence of new forms of services or new technologies or changes in societal values. But at the same time, predictability is fundamental. And we cannot have unlimited policy space, particularly in a international rule system. Should be a balance between the two values, I think. And just a last comment that I wanted to add to the question on services. Well, it depends very much if the measure is in breach of one of the commitments that the country may have in, for instance, for road transportation or for maritime services.
Gustavo, you have the last 30 seconds to you.
Thank you.
No, I don't have a, if I got your question right, I don't have a statistic on the use of the general exceptions by the developing countries. I just noted that based on the reports of the WTO appellate body and panels published, Article 20 was invoked in 33 different disputes, and 23 of these 33 correspond to developed countries that invoked the general exception. So that's 70% of the time. And I use that to highlight the fact that it is very important for developing countries not just to preserve a space of policy, but also to avoid any abuse of a general exception. So the jurisprudence, for me, I think it was very correct and useful for developing countries that was able to strike a balance on. For developing countries, also very, very important to prevent the abuse of general exceptions. So.
Thank you, Gustavo. And I suppose that comes back to the answer to our German colleague's question, which is, bearing in mind the policy space and the balance, what precisely you can do depends on where you're falling within that balance between the disciplines and the policy space. So perhaps we could have a longer discussion of that after we break up. But our colleagues, the organizers, are keen to keep us on schedule here. So I think, unfortunately, we'll have to finish there. I would like to thank you for coming, and please don't hesitate to approach us with any additional questions you may have afterwards. I'd like to thank our colleagues from ICTSD. Gracias al equipo técnico por su apoyo. And also, thank you in particular to our speakers, Alejandro, Cherise, and our guest speakers, Jaime and Gustavo, for taking the time out of a very busy schedule relating to the ministerial to come and join us. And thank you again, and time is always too precious in these things, but please don't hesitate to approach us with questions. So good evening, everybody. Thank you.